Hi friends, in this video we're going to look at what can work for a waiver based off of hardship to a U.S. citizen child. Even if you don't have U.S. citizen children, let's say you're filing a waiver based off of a U.S. citizen or lawful permanent resident spouse, you'll want to look at these arguments because they could apply to you if you have a similar situation. And we're going to also have the latest processing time updates for 2024 based off of our recent approval. So you'll want to stay tuned. My name is Kaushik Ranchod. I'm an immigration lawyer. I've been practicing for over 20 years. Let's dive into it. In this case, we got a J1 hardship waiver approved based off of exceptional hardship to the U.S. citizen daughter. The J1's daughter could not remain in the United States without her parents, as her mother was also subject to the 2-year home residency requirement. The family situation was further complicated by the fact that the child had a well-documented medical history, and based off of this medical history, it made it inadvisable for her to go back to Pakistan. Now, this case did receive a request for evidence, which is an additional hurdle that we had to overcome to get the case approved. In the request for evidence, it's extremely important to respond to all of the questions that they're asking, or to address all of the questions that they're asking. And that's what we did in this situation to get the case approved. Specifically, we documented the medical condition and provided substantial medical advice indicating that relocation to Pakistan would be detrimental to her health. We also detailed the country conditions in Pakistan, emphasizing the inability of the J1 and his spouse to provide for their daughter's essential necessities due to the lack of adequate medical facilities and support systems. Furthermore, we highlighted the J1 contributions to the U.S. during his J1 program. We argued that the J1's continued work in the U.S. was valuable and that his waiver was sought out of necessity for his daughter's health and well-being. Now, I've talked about this on prior videos. It's extremely important to demonstrate exceptional hardship in two scenarios. One would be relocation and the other being separation. We stressed that separation would be impossible because the daughter could not stay in the U.S. without her parent. And relocation also provided significant health risks to her. Now let's look at what the processing times were for the case as well, so you get an idea of what processing times are looking like in 2024. We filed with USCIS and Department of State on January 3rd, 2023. The USCIS issued a RFE on October 24th, 2023. The Department of State processed the I-613 from USCIS on April 10th, 2024. And the Department of State issued a favorable recommendation on July 9th, 2024. So you'll see here that it took about 9 months for USCIS to issue an RFE and about 1.5 years before Department of State approved the case. The case has not been approved yet with USCIS. Usually once Department of State approves the case, USCIS issues the final approval. So we're just waiting for that final approval. They already did issue that 613, indicating that they recommend approval when they sent that over to the Department of State. I want to thank you for taking the time to watch this video. By watching this video, you're bettering yourself. By bettering yourself, you're bettering your family. And by bettering your family, you're bettering the world. Thank you, and bye for now.